Hello viewers, this is a pertinent court case where a candidate who after passing the senior secondary examination 10+2 from Central Board of Secondary Education in 2017 participated in the National Eligibility Cum Entrance Test and after going through the counseling process conducted by the counseling board got admitted to the concerned dental college in BDS degree course. However, just before the first year BDS examination, the student had applied for the enrollment in the university, and in response, the university informed him that he cannot be allowed since he had failed in chemistry in senior secondary examination. Now we will go into the history of the case. A candidate after passing CBSE 12th examination participated in NEET examination and was successful with the required rank for admission into a dental college. The candidate was issued with a provisional allotment letter to join in a dental college and joined there and started undergoing course. During enrollment process undertaken by the concerned university to allow him to take the university examination in the first year of the university, it was noticed that he failed in the one of the core subject which makes him eligible to join the BDS course in CBSE 10+2 examination. It appears that the eligibility of the candidate to join in that course remained unchecked by the concerned authorities, and no effect was taken to verify the eligibility at the initial level at the time of joining the course. The CBSE on its part had submitted that they have not committed any error or human error while issuing the mark sheet. The CBSE provides that a candidate has to appear in a subject which comprises of theory as well as practical. She is required to secure minimum 33% marks individually in each component, that is, theory and practical, and if a candidate does not acquire 33% marks in both components, she is declared failed. The respondent college has taken a stand that since the counseling board had sent the petitioner after allotting college, they honored the decision of the board, and as such, the college has not committed any illegality in granting admission to the student. The counseling board replied that it is the responsibility of allotted admission college to check the original documents and the documents pertaining to the eligibility of the candidate, inclusive of the mark sheet of 12th standard of the candidate, and then report to the counseling board about the details of admission of the candidate via online reported module. Two important questions which are required to be decided by this court are as under: whether the petitioner was eligible to appear in the examination for BDS course, and after granting admission, whether he was entitled to continue since he had undergone the course for 1 year. 2. Whether the candidate who has been admitted in the BDS course due to omission and lapses without having eligibility, and his precious time is wasted by the different authorities, then such a candidate can be compensated by this court, or he can be granted admission to complete the course. The court will deal with the role of each of the authorities as how they have committed fault and lapses in giving admission to the candidate. The court finds that shifting of burden by one authority to another is absolutely an afterthought, and the same cannot be accepted by this court. The court finds that the candidates who appear in pre-medical qualifying test are of young age and do not have full maturity or understanding. These students are misled by the authorities, including statutory authorities. The loss of 1 year for a student is a great loss for his/her entire career. The aspiring students in medical course prepare for these qualifying examinations after devoting their entire time for a considerable period. The selection itself is a Herculean task after facing very tough competition. The court finds that in the present facts of the case, the Respondent Counselling Board as well as the Respondent College both are guilty of giving admission to the petitioner and have wasted one precious year of the candidate. The court finds that since the petitioner cannot be granted admission, at least he is required to be compensated by both the authorities, that is Counselling Board and the college, for the lapses committed by them. The court in the present fact of the case deems it proper to issue direction to pay a compensation of Rs.10 lakhs to the petitioner student by the board, and further the dental college and hospital will also pay Rs.10 lakhs to the candidate. The payment of compensation to the candidate will be made within a period of 5 weeks from the date of receipt of copy of this order. With the aforesaid direction, the present writ petition stands disposed of.